Good morning. I think the time has come to start this webinar because the time will rush on if we don't. So my name is Nikki Padfield, and it's a very great pleasure to introduce this webinar on behalf of the Cambridge Centre for Criminal Justice and the William Harvey Research Institute, the future of the Coroner Service. As probably most of you know who are here, we organised the webinar to coincide with the government's response to the Justice Committee's report on the Coroner Service, designed it to cover some of those central issues, but sadly the government's response is not as we hoped yet in the public domain. So I think we will in many ways be focusing on the main findings of the Justice Committee's report, and I've summarised them for my own purposes under four main headings. One is the Justice Committee's view that bereaved families are not yet sufficiently at the heart of the process. And I think it is really important to consider whether the creation of a national coroner service would or would not make a difference. They are also very critical of the long-standing significant shortfall in pathology services. They're very critical of the Preventing Future Deaths regime. And then, of course, there are criticisms of legal aid. There's so much to explore that I'm delighted to pass the floor immediately to Andrew Harris, who's been a senior coroner in London at Southwark Crown Coroner's Court for 10 years or more, and is Professor of Coronial Law at the William Harvey Research Institute at Queen Mary's University, London, who's going to chair the first session. But before I hand to Andrew, a tiny bit of housekeeping, if you like. We've divided the session into two sessions. Each has two speakers. We're going to invite the two speakers to speak one after another, and then have questions and discussion for about 20 minutes afterwards. So please do record questions at any stage. Please use the Q&A function. We will be using the Q&A function largely. We will indeed be looking at it afterwards for any questions that we've missed. We may get back to you afterwards. And the whole session is being recorded and will be live probably tomorrow, which is the moment for me to thank Dan Bates, without whom I would certainly be lost, our technical whiz for webinars. Thank you very much, all that you do invisibly, Dan. But now let me hand straight on to Andrew Harris to chair the first session.
So good morning, everyone, and thank you so much for coming out of your busy days. The first session is the bereaved people and funding the Coroner Service. And I'd like to introduce Mayor Sikand QC. Mayor's a civil liberties and human rights barrister whose practice focuses on holding public authorities to account through private law claims, deaths in custody inquests, and public inquiries. Mayor.
Thank you. First of all, thank you so much for having me. It really is a privilege to be amongst such brilliant thinkers. And second, I'm going to start with a disclaimer. I will offer you a view from the English bar, but it is most certainly not the view. My view is entirely coloured by the fact that I act for the bereaved and not for state bodies. But in preparation for this talk, I have spoken to a number of colleagues, so you're not lumbered with my view alone. But again, these are colleagues who act for the bereaved. I don't apologise for that. I just wanted to make that plain at the outset. So when carrying out research amongst my colleagues, four main themes emerged, which really chime with some of the issues raised in the report, and so they're not in the least bit surprising. But before I embark upon a critical analysis, I first want to acknowledge how far we have come in this jurisdiction. I did my first inquest about 25 years ago, and I still remember it, not least because I was instructed by one Sadiq Khan But anyway, in that inquest, there was no legal aid. We didn't, and it was a death in police custody. We didn't get any disclosure in advance of the hearing. We would get the witness statement of the witness in question when they came into the witness box, and then we would have to ask for an adjournment to take instructions. And all we would get was 5 minutes, and then we'd have to all come back in. And that was apparently, fine and inquisitorial. We did not have the infrastructure we have or the rules we now have. And of course, this was pre the Human Rights Act. This was pre-Middleton, which some of you will know is the seminal decision of the House of Lords, which allowed us to look at inquests through the lens of Article 2. And so there was no notion of an Article 2 investigative duty. In my view, inquests can be very effective and if conducted properly and with sufficient resources. Of course, that begs the question as to what a properly conducted inquest is, which takes me back to the 4 themes. The first complaint or theme, and I'm afraid it was an overwhelming one, is the inconsistency of the quality and, dare I say, knowledge base of coroners and assistant coroners. And this is a direct quote. If they were all before Andrew Harris, things would be so much better. Now, I don't want to embarrass Professor Harris, but the recurring question is, why aren't there more coroners like him, or at least a bit like him? And this is not a personality point. And I don't want to spend too much point on this first issue, because in every judicial or quasi-judicial role, there will be a range of ability and a difference in approach. But I should note in passing that the Colonial Service is out of step with other courts and tribunals, because recruitment does not take place via the Judicial Appointments Commission and is left to local authority processes. However, the complaint from the bar is really about consistency of practice across the jurisdiction. And these inconsistencies are not just about the difference in emphasis or the way discretion is exercised, but about the treatment of families and the decision-making that goes to the core of an effective inquest. For example, some coroners simply read out the witness statement prepared by the state body on behalf of the state employee when that witness comes into the witness box. That is their examination. That is the examination by the court. Also, as far as I'm aware, and I could be completely wrong about this, coroners are not trained on trauma as such, and their practice is not trauma-informed, and this can have a very real impact on the bereaved. I note that the Justice Committee report recommends that the Ministry of Justice should implement a statutory charter of rights for bereaved people modelled on the criminal justice system victims code. I mean, that may mean that families are treated differently, despite coroners trying very hard to make sure all interested persons have the same status in an inquest. One of the other very grave inconsistencies in coronial practice is the approach to disclosure, which segues nicely into my second theme, which is disclosure. Yes, there is an inconsistent approach by coroners. Some refuse to allow cross-disclosure and insist on being the filter. There's nothing wrong with that in principle, but what it means is, in reality, you may never get the disclosure because coroners are so busy, or you get it far too late, again, because they're so busy. Some will only direct very limited disclosure, not wanting to overburden government departments or the NHS. The trouble with that approach, certainly from my perspective, is that it simply reinforces bereaved families' suspicions. And one of the crucial functions of the inquest process is to allay suspicion. So the disclosure decision-making is absolutely fundamental to an effective inquest. Of course, there has to be a proportionate approach, but the rules as currently drafted are wholly inadequate and simply not fit for purpose. Families are left at the mercy of the coroner or the state bodies, or in fact both. In my experience, there's a very real reluctance from some public bodies to comply with what we call the common law duty of candour. And thus far, that duty has not been put on a statutory footing in the coronial jurisdiction. There are no penalties for late or non-disclosure in the coronial system, unlike the civil litigation system, and that can inform the approach of certain public organisations. That problem is compounded by an under-resourced coronial system with inadequate administrative support to chase every government body for documents that they were meant to serve and did not serve. There are, of course, examples of good practice, more usually found within the NHS, where the candour extends to an acceptance of failings as well as full disclosure. Of course, the NHS is now bound by a statutory duty of candour. But in order to embed that good practice and also to ensure consistency in coronial practice, in my view, there needs to be a change to the rules and an extension of the duty of candour. The next complaint is another well-known, well-discussed, and I think probably uncontroversial one, and that is the limitation of public funding for the bereaved. I'm not going to rehash what has already been said about the equality of arms principle, but I do want to say something about the Ministry of Justice's infuriating suggestion that if you extend legal aid, you alter the very nature of the inquest. The report quotes the Ministry of Justice in a 2018-2019 legal aid review. I'm going to quote the bit that in my view is nonsensical. They say, we're mindful that a significant expansion of legal aid could have the unintended consequence of undermining the inquisitorial nature of the inquest system. It could also reinforce the commonly held misconception that an inquest role is to apportion blame, as opposed to finding fact and learning lessons. All the work we have done affirms the need to maintain an inquisitorial system and highlights the crucial role of the coroner in achieving this. Now, this appears to suggest that things only get adversarial when the bereaved family is represented, and therefore they will only allow funding in a very limited class of cases, and that is where legally they effectively have to. That is to say, where Article 2 is engaged, and also in this other category of cases, and that is where the Director of Legal Aid Casework has made a wider public interest determination that the provision of advocacy for the bereaved family at the inquest is likely to produce significant benefits for a wider class of people. I should say that in all my years, I have never had a case that the legal aid agency says passes that second test, not ever. Anyway, I want to go back to this issue of inquests being too adversarial and debunk a few myths. First, the inquisitorial system doesn't mean you don't press for the truth. And how do you do that? For example, if you have a lying witness, it is surely your duty to your client and to the court to demonstrate that, or once established, to press for the reasons why, what is behind the lie. That is surely fundamental to reaching the truth. Equally, if there is a disputed factual matrix, you cannot reach the truth without seeking to establish which version is correct. Ultimately, of course, it's the matter for the jury or the coroner, whoever the fact finder is, and they will decide. But if there is a fundamental dispute of fact, it requires robust questioning. That is not adversarial, that is inquisitorial. The idea that funding families in a wider class of cases would somehow tip the balance from inquisitorial to adversarial is difficult to comprehend. State bodies are always represented, in my experience, well, certainly in the cases that I do, by lawyers. And my experience is that those lawyers can be terribly adversarial. They routinely put cases to their witness, as they see it, in what they consider to be re-examination, and not just as a retaliatory gesture to robust cross-examination by the family, but because of an institutional defensiveness or a perceived need to protect reputation, and because they have an eye on civil litigation that might follow. That approach is ingrained, and coroners are well used to regulating the tone, like any judge does in any jurisdiction. But I think there's a different point to be made. there's a few different points to make. First of all, if we want a system where all interested persons work together to reach the truth and to learn lessons, then we do need to resolve the fundamental issues about disclosure and candor and institutional defensiveness. There is a further difficulty with the way in which the public funding regime works, which impacts, I think, on the way in which the Lawyers for the Bereaved act. The way it works is it actually forces families to approach the inquest process as one of blame. And why do I say that? The Article 2 argument is absolutely fundamental to securing legal aid, exceptional case funding. The legal aid authority will usually want a ruling from the coroner on the issue before making a determination, which is in itself frustrating as the family needs representation at the very first pre-inquest review. Anyway, to get funding, we have to get an Article 2 ruling, which means we have to search for arguable faults at the very outset. We have to look for operational or systemic failings, literally as the very first thing we do in order to secure legal representation at the inquest. It sets the tone and it gets everyone's hackles up. If there was a non-means tested legal aid where the state is represented or implicated, then Lawyers for the Bereaved would not have to begin the process in this way. They could play a fundamental role in allaying suspicions, in taking the family neutrally through the process. There are a large number of cases which don't meet the Article 2 threshold, but involve the state and which require lesson learning. For example, care homes where people are not under a dole's order, absconsions by voluntary patients in psychiatric hospitals, after which people take their own lives, recent contact with the police before death ensues, police removals under Section 1236 of the Mental Health Act. I could go on. If Article 2 did not make the difference, that is arguable fault finding, and given the case law suggests that there should be no difference in scope in an Article 2 and a non-Article 2 inquest, then the inquest process can at least begin more neutrally. Now, the last recurrent theme, and I'm going to run out of time, is the lack of national oversight, ensuring that the critical conclusions and preventing future death reports are properly taken on board and improvements made. And I know this is a theme that that Professor Padfield is going to take up. From a practitioner's perspective, acting on behalf of families, it is absolutely soul-destroying to turn up at an inquest where, for example, yet another person has died in the same prison, and the jury's critical findings mirror the findings of many juries before them. And the last however many PFDs have been paid lip service to, the same mistakes have been made. My colleagues and I would say to the government, fund a national oversight body, and there will hopefully be fewer inquests, because the purpose of PFDs is to prevent future deaths. So lives will be saved. So that's it. Thank you for listening.
Maya, thank you very much. That's very accomplished in exactly the right time, touching some familiar themes with great panache and very thought-provoking. Thank you. We're going to move straight away, but not stopping anyone wishing to put questions on Q&A to pick up at the end of this session, for me to introduce Ian Freckelton QC. I mean, firstly, I should say, Ian, thank you so much from coming from Australia in this remote session. I know you've had a miserable time with all the lockdowns over there, with the handful of cases you have, and it's wonderful you've agreed to be with us. Ian is an experienced QC in Victoria, who's also Professor of Law and Psychiatry at University of Melbourne. He's written extensively on coronial law and procedure and appeared in many of Australia's best known inquests. And so, Ian, a view from Australia.
Thank you very much, Andrew. And just bear with me for a moment while I try to get the overheads in good order. Are those showing all right?
That's good, Ian.
Good. All right. Well, thank you very much for inviting me. It's a great pleasure to be part of this symposium. Let me say that I have a particular dislike of people, and there is one country which has a propensity to do it, who come from that country and maintain that everything that they do in their country ought to be emulated. I promise you I won't be suggesting that about Australia. Australia has many positive attributes. I say that coming from South Africa, and that beach there that you can see is one of them, which I was at a few weeks ago. But it has a variety of other less attractive attributes. And I'm going to try to give you a balanced perspective on some of the initiatives which have been trialled in Australia. You can view Australia as something of a coronial laboratory, if you will. There are some things which are worthy of emulation, and there are some good lessons that can be learned about things that ought not to be copied. So let me give you a little flavour of the world of coronial practice in Australia. There are multiple jurisdictions in the country, and it's a little like Canada. There is different coronial legislation in each one of the states and territories. And the differences are of some significance in their variability. There isn't a national coroner's court or service. So when someone dies, the inquest takes place generally in that location according to the rules and the legislation applying there. I'll say some things generally about what is taking place in respect of coronial legislation and its evolution in Australia. One of the initiatives that is entrenching is an elimination of regional coroners who are, for most of the time, magistrates, and instead a centralisation of functions, recognising the specialist nature of the jurisdiction, of its practitioners, and most particularly of its coroners. The same is taking place increasingly in relation to the forensic medicine and pathology assistance which is provided to each of the courts. And there is a move toward co-locating those facilities, not in the same building, but often side by side, so that there can be meaningful work together and a synergy of energies. There are manifest advantages to this combination of changes, with an improvement which is discernible in terms of expertise and specialization, as well as consistency of approach and a sharing of knowledge more generally. The downside is that it means that people have to come some distance to coronial inquests where they are convened, and I'll say more about that presently. And so there's something of a disenfranchisement of those who are rural and regional. And in a country as large as Australia, that's a meaningful issue. Let me say something about the status of coroners' courts. In Victoria, which is often regarded as having the most avant-garde legislation and practice in the coroner's area in Australia, the coroner's court is named in legislation as a separate inquisitorial court. It's not part of the magistrate's court, it stands alone. Its head of the jurisdiction, the state coroner, is an intermediate level judge. And that's been an overt attempt to elevate the status of the jurisdiction generally. But what it means to be an inquisitorial oasis in the adversarial landscape is still something that is being thought through. What attributes of inquisitorial process are appropriate, given that there will be entrenched differences of approach? That's still being worked through and thought about. Another issue that is a subject of contemplation, rumination maybe, is how to integrate concepts such as therapeutic jurisprudence, trauma-informed practice, as was mentioned earlier, restorative justice, and even family conferencing into the processes of not just inquests, but investigations undertaken by coroners, recognizing that in Australia, only a very, very small percentage of cases which are the subject of coronial investigation go to open inquest. Now that those issues are not uniformly addressed throughout Australia, and in some parts of the country, coroners' courts still have a second level status, being merely a division of a magistrate's court. One of the other things that's happened in Australia is the reduction in the incidence of autopsies, and to a dramatic level. Now, surgical postmortems are undertaken in fewer than half the cases that are investigated by coroners, with CT scanning being used routinely in most of the jurisdictions, and an MRI scanner having been made available this year for the Victorian Institute of Forensic Pathology. And that's been really quite transformative in terms of how investigations of cause of death are undertaken. There are processes which are formalized under the legislation for objection to what I'll call surgical postmortems, and processes for appeals within courts, and then to the superior courts, the equivalent of the High Court of England and Wales. That's had many advantages in terms of costs and reduction in distress to families and incorporation of them into the investigative processes. But of course, again, it comes at something of a price in terms of a reduction in the extent of information coming before coroners, as well as some level of reduction in skills and practice in the forensic pathology area. Let me say something to you, but only briefly, about funding. It's variable around Australia. The high watermark of funding in Australia and in the world really is the Victorian Coroner's Court. Victoria has a population of a little under 7 million. It has 13 coroners. Each one of them has their own solicitor, a substantial prevention unit. All up, the court has 61 full-time staff and 25 part-time. Last year, they completed a little under 7,000 investigations, and the cost per case was approximately £2,000 each. So it doesn't come cheaply. Only 58 cases took place before with an open inquest. That's fewer than often, and a product of issues to do with COVID, but nonetheless, it gives you a flavour that only modest numbers of selected cases actually go to an open inquest, but a significant number of recommendations. Assisting the Coroner's Court and functioning in a variety of important ways is the Institute of Forensic Medicine in Victoria. They undertook some 7,000 medico-legal investigations with a little under 3,000 autopsies, 3,500 external examinations. Their funding ran to just under $46 million, so something in the order of £22 million. 119 full-time people and 48 part-time employees there. So you can see that it's a very different scenario to the coronial jurisdiction in many other parts of the world. In New South Wales, these issues are controversial. New South Wales looks, I think they'd admit openly, with some level of frustration at how things function south of their border. And there's a substantial investigation which is being undertaken at the moment into how the jurisdiction is functioning in New South Wales and the extent to which it needs to be changed, updated, and improved. Their system, by contrast, has a beautiful new building for both the Coroner's Court and for the Institute of Forensic Medicine, but far, far fewer coroners, and there's still some modest level of regionalisation of functionality in New South Wales, and a perception amongst most who practice in the area that needs to change as soon as possible. Juries are not used in coroners' proceedings in Australia any longer, and that has a variety of outcomes that you would appreciate immediately. Many positive sides, not too many negative. Let me say to you a few words about innovations of practice and function in Australia. And for this purpose, I'll concentrate just on Victoria. The big feature that distinguishes Victoria is that institutions that are the subject of recommendations by coroners have to respond within 3 months. They don't have to comply, but they have to say what they're doing. And if they're not doing anything, they have to explain why that is. Findings are in narrative as against verdict form, and both findings and recommendations have to be published in full on the court website. That means a dramatically improved accountability and a substantial improvement in quality too. That's really quite identifiable from the time that this came into force. There's a Coronial Council which advises the Attorney General on issues of practice and law. They've written a number of reports which are all publicly available on things like bereavement services, dealing with suicide, how to define reportable death, rights of appeal, and definitions of reportable deaths in terms of medical procedures and hospitals. Coroners can refrain from making findings about circumstances or manner of death if there is no public interest in their doing so. And that means that there will not be an open inquest and the process is quicker, which has some benefits, of course, for families. But this does not mean there are not controversies. There are controversies aplenty. The principal amongst them is the extent of delay between death and inquest, and even between inquest and delivery of findings. Most in the system would say that that's unsatisfactory and really problematic. Some coroners are better than others. Some are quicker than others. Some are more probing and analytical than others. They're all full-time. They're professionalized. They have training. They have court books, court manuals, court protocols. But of course, there's variation in quality. There's dissatisfaction to some degree enunciated, and we know that because surveys have been conducted, auspiced by the court, about the extent to which family members are alerted to what's taking place, how they can contribute, how the process functions. Allied with that, there are some misunderstandings about what coroners do and how they do it. I've adverted already to the very modest numbers of open inquests. Many would say there should be more and that there should be fewer findings in chambers. Overlaps exist between what coroners investigate and how they do it with other investigators of death, aviation, maritime, workplace, and similar. There are tensions sometimes between coroners' courts and institutes of forensic medicine, and they require subtle working through and sensitive working through, as you would expect. The issue of attachment of blame rather than focusing upon systemic flaws and deficiencies is a live one in Australia, as it is in most countries. Not fully worked through because there are times when there is fault, and many of us would say that needs to be called out. There are issues still to do with the real, actual implementation of recommendations rather than rhetoric from entities, especially within government, about their response to what's been proposed by coroners. Australia doesn't have human rights legislation the same as in the United Kingdom. 3 jurisdictions do have human rights legislation, but the level of integration of human rights principles, which has taken place in England and Wales, does not have a full equivalent in Australia. It's talked about, it's thought through, it's referred to, but it's not, I would say, as sophisticated as has happened in the United Kingdom in latter times. Bereavement and counselling facilities are annexed to the courts to differing degrees, and in fact the Coronial Council in Victoria is undertaking an inquiry into the need to improve such facilities to support family members right at the present. The fact that police assist coroners in police death inquests is controversial for reasons you would understand immediately. There's no easy answer to that conundrum, and so it continues to be an issue of controversy. And the availability of legal aid for parties is highly problematic. It's grossly inadequate, meaning that one cannot speak in terms of equality of arms. And in spite of many representations about the need to improve that situation, minimal progress has been made with legal aid budgets stretched to breaking point. So a very last few words for me. There are a number of challenges which are being wrestled with in Australia as in the United Kingdom. But what we're seeing is that COVID-19, ironically, has given something of a fillip to reconceptualization, modernisation, and even professionalisation of how coroners' courts in Australia are functioning. And that's, of course, to be welcomed. There is an integration of courts' functions with the providers of forensic medicine services, and having them working harmoniously and collaboratively manifestly has advantages. There's a recognition too that if secondary trauma is caused by coronial processes, if the system doesn't work well, if it's too slow, or if it's insensitive, that has outcomes which are deleterious, some of which can actually even be measured financially. And so many of the arguments and the debates are now being framed in terms of what is value for money, what needs to be done to enhance the functionality of the coronial system so that it focuses upon what is most important, what particularly needs to be addressed, leaving other things which may be a touch peripheral less attended to. There's been a consolidation of structural changes in Australia, and although the legislation varies somewhat, what we are seeing emerging is hybrid courts with inquisitorial elements predominant, but with some adversarial components, unsurprisingly. And the making of recommendations as well as findings directed to avoiding avoidable deaths in the future is a more and more overt focus of the coroner's courts, and that I think is something constructive. So there are positive elements. I don't recommend emulation of everything in Australia. There are some good things from which lessons are to be learned. There are some risks, there have been some errors, and there's plenty to reflect about, and I'd be pleased to discuss those with you at your convenience.
Ian, thank you very much. That was hugely informative, a wonderful spanning of the range of jurisdictions in Australia with much for us to learn and think about. So we now have a panel question session, and I'd like to start the questions with a question about the Judicial Review and Courts Bill that is before Parliament. And I think that has two parts, and I think it's for both of you to comment on. Firstly, there's a suggestion from Ian that actually there are too few inquests being held in Australia, and there's a general sense in this country's jurisdiction that there are too many. And the Judicial Review and Courts Bill, as you know, proposes written inquests if the interested persons agree. And I'd like you both to consider how we achieve the right balance. And the second question comes from Deborah Coles of Inquest, who asks whether you see anything in the bill that will help take forward the Justice Committee recommendations to put the families at the heart of the inquest process. So, Mayor, would you like to start on that?
Well, I suspect, I think it's Louise from Inquest who asked that question, and I suspect she asked that question because she knows the answer, that there appears to be little in the bill, and I've only had a cursory reading of it to put families back at the heart of the process. In fact, it appears to be doing the opposite, reducing the number of inquests, extending the kind of non-jury requirement for COVID-related deaths. And so I suppose the answer to that is no. But there is also a move, isn't there, to put the remote remote inquest on a statutory footing, which includes allowing the coroner to be remote as well, which is a bit worrying, only because if you're sitting with a jury, it's difficult to understand how that would work. I know, for example, having remote inquests has relieved the burden considerably during the pandemic, and I've done a few remote inquests, but I did one which was 3 weeks long remotely, and throughout the whole process I could not see the jury, and I have to say it was very challenging, and I had to keep asking myself, do I have the right to see the jury? Do they have, I mean, they can see me, but does it make a difference to my advocacy? Shouldn't I see my fact finder? Apparently, my particular coroner didn't think it was necessary, but this is a long-winded answer to saying I can't see anything in this particular bill that changes the status quo for families. It may be useful to coroners and the system as a whole, and you'll know more about that, Andrew, than me.
Ian?
I come at things from a slightly different perspective. As being most used to a coronial jurisdiction that doesn't have juries, having started my career when there were coronial juries, I must say I don't think we've lost a great deal in no longer having them, but that's dependent upon the quality of coroners, their independence, their preparedness to make robust decisions. I agree entirely that families should be central to the process, but I'd like to make a plea for other parties also to be recognised as integral to how the process functions, because there are more people damaged by avoidable deaths than family members. Those instrumentally involved can be devastated by what's occurred. Their careers can go awry, their confidence to pursue their vocations can go. Staying away from doctors and others, just think about bus drivers and train drivers, persons who find deceased individuals in cells. They have an interest in what takes place too, at an emotional level as well as a factual one. And yes, families who are bereaved must be at the heart of a process, but there are multiple interests which need to be taken properly and sensitively into account in the whole process. So yes, there are I think there are some significant changes which are being talked about. I always worry when decisions take place away from the public eye, and one doesn't want too much of that. What there needs to be is a check and balance, so that if there are situations where coroners do not convene open inquests, that parties have an adequate opportunity to make representation that not take place, and that the hearing be public for reasons which go to the community's best interests. I think there's an attempt to orchestrate that in what is proposed, but it's certainly something that needs to be looked to very carefully, because we in Australia have probably too many cases which are genuinely, essentially controversial, dealing with important issues which are not adequately seeing the light of day.
Ian, just on that point, I mean, we know that the federal laws in a number of states give more discretion about opening an inquest, about the notification, opening and discontinuance than they do in this country. Is that a good thing?
By and large, it works reasonably adequately. Things are delayed for criminal proceedings. The inquests continue unless there's a need for further investigation and obtaining of new evidence. It isn't as though the flexibility of processes results in a poverty of investigation. So I don't think that's so much the problem. The issue is one of selection of those matters that are deserving of expenditure of effort and money on public airing of issues. And it does seem to me that the numbers are becoming too few in a number of jurisdictions. That's something you wouldn't want to emulate.
Mayor, one for you. Kevin McLaughlin asks, has the distinction between Middleton and Jamison inquests outlived its usefulness?
Well, we're told that there is little distinction now by the courts above between the scope of a traditional Jamison inquest and a Middleton inquest. The difference remains in the conclusion and what can be, you know, the kind of critical narrative. I mean, for my part, I'd be delighted if we just simply had Middleton type inquests, so there can be critical narrative conclusions in every kind of inquest. But I'm afraid the majority of inquests are still Jamison type inquests. So I'm not sure what outlived means in these circumstances. Certainly there is no distinction in scope, but the outcome is the crucial issue.
Ian, in complex state deaths in Australia, do they have a similar approach to scope and breadth of conclusions as we do in our Middleton inquest?
Yes, yes.
Yeah.
All the precipitating and preceding events and influences are traversed in a critical way. But that also occurs in a wide variety of scenarios. So the state death situation is not qualitatively different from the general approach in inquests more broadly. So if there's a strange death in a hospital or in a truck accident or an aeroplane accident, it's the same kind of thing. The same approach of narrative analysis of precipitating and precursive factors takes place.
Oh, well, we don't have that, do we? I mean, that's interesting, because that would certainly change the landscape if it was possible in certain non-Middleton cases to have a sort of wider scope, as well as looking at the circumstances and be able to be critical, as you say, Ian. We do have this sort of binary approach in this jurisdiction, which I don't, yeah, in that sense, I would say it's an unhappy binary. There should be some other way.
I agree with that. As long as one's discerning about the extent of and scope of investigation, to remove that kind of fetter, I think, is constructive, and it's had some extremely positive outcomes in terms of changes that have been able to be explored and later, of course, implemented.
Maya, when I have US students who come to attend my court and learn of the English jurisdiction, very often their comments are complete disbelief at the number of different processes of investigation and overlap that happens in the English jurisdictions. Do you think that the Norfolk case is the right direction of travel in limiting the scope of coronial inquests?
So yeah, it is a case that is routinely relied upon to prevent a resumption of an inquest. I don't think you can replace the coronial process, but for lots of reasons in terms of what is important to the family in that process. So if there has been another investigation, it depends, in my view, the extent to which the family was involved, the extent to which it was open and public. But often these other investigations, whether it's a domestic homicide review or in the Norfolk case, a sort of disaster type investigation, the family aren't at the heart of that. And if we're going to say that families are at the heart of the inquest process, then that makes a sort of mockery of the process, and you get there's a lot more to it reaching closure throughout, during the process is also something that is really important. Seeing witnesses, being able to ask those questions, to have them answered, to have your advocate ask the questions that are of burning importance to you, whether they're causative or not. And I do think that case and others, there's the is it Grice, the case which is the opposite. There's an opposite case about where there's been a domestic homicide review as to whether or not an inquest should be resumed. I think that case is quite limiting and perhaps needs revisiting.
Thank you.
I
Ian.
think the challenge here is to harness what other investigators do so that coroners can enjoy the fruits of other investigations and use them, not replicate them, but come in over the top in the public interest, looking at the broader issues. And that's a challenge for the coroner's jurisdiction.
Thank you. Ian, Penny Cooper asked, what does a hybrid inquisitorial and adversarial process look like?
It involves tempering the adversarialism, thinking less about the parties being wholly in conflict, looking for middle ground, recognizing the interests of family members in the reputation and conduct of their loved one, an increase in respectfulness within the system, and it involves more involvement on the part of the coroner in driving what takes place, and something of a reduction in the authority of the parties to shape what takes place in the court. And most of this goes to the very heart of what coroners do in both of our countries. But around the edges, working through how best to integrate the perspectives of family members into what takes place in a coroner's court is actually quite challenging.
Maya, an anonymous question for you. Does the recent Chief Coroner's guidance in relation to pen portraits confuse the distinction between a court hearing and a service of remembrance?
Well, the guidance, I think, is a long time coming because there is such a difference in practice from coroner to coroner, and state representatives would often say, why should they be allowed a photograph, and why do we need a pen portrait, etc. And so I'm pleased there's consistency is the first point, because coroners will know how to follow that guidance. I wish there was more guidance on a number of other issues, so there would be consistent practice across the jurisdiction. Does it turn it into a memorial service? Well, part of it goes back to that whole thing we talk about, Bereaved being at the heart of the inquest, and that is an important acknowledgement that you're not just dealing with a dead person, you're dealing with somebody's loved one, and it's important to acknowledge that who they were as a person, whatever the circumstances of their death was, and to know something a little bit about them. And I think it's tremendously important to families to have that if that is what they want. Some don't want to have detail about their background. And no, I don't think it turns into a memorial service. I think it's fundamental to the process and cathartic, and I'm glad it's there.
Thank you. Ian, a question from Aaron Barbara for you. How did Victoria come to fund such extensive services? Is there a history here that we ought to emulate in order to secure funds for innovation and excellence in this country?
It's a question which the other jurisdictions in Australia regularly ask themselves as to how they can get access to equivalent amounts of politicians' funding, there wasn't a particular precipitating factor. Much of it arose as a result of an Attorney General who was sensitised to death investigation issues and keen to have the system working better, and who was persuaded that injection of more funding would have a variety of pro-social outcomes.
Thank you.
Can I just comment very briefly, Andrew, about the memorialisation issue, that it's something we have to be really careful about. It's obviously a balance, and allowing further input from family members that's respectful and humanising and individualising is really positive. But we mustn't forget that sometimes there are different perspectives within families of a deceased person, and there can be some very uncomfortable situations where some family members have one view of a person and want certain things to be remembered and emphasized, and others have a diametrically opposed view. So it's one of many reasons why we have to be cautious in terms of how we allow some people within family units to portray issues to do with their family members. It's not to say we shouldn't do it, but it's one of those things where it's a matter of balance.
There's another anonymous question. Is it proportionate and respectful to all bereaved families that a single terror-related inquest can cost the, sorry, it's now just moved annoyingly, can cost the entire budget of a jurisdiction?
Mayor?
Oh, is that to me? I don't know if that's a reference to Westminster
Well,
Bridge, but
High Court judges appointed to conduct inquests is something which costs a lot of money, often with counsel to the coroner, and I think the question asked is whether that's proportionate to the funding of other inquests.
well, a terrorist attack, so-called, which results in multiple deaths, is a matter of national interest, and it's a matter that affects our whole nation, because that could have been any one of us, and it is of profound importance to seek to try and prevent deaths such as those that go to our daily liberty and security. So I don't know what the budget was, and I don't know if in fact there was funding available for most of the families, but I don't think it's disproportionate where there's been number of deaths.
Thank you.
In Australia, but it's a matter of balance, isn't it? But it's just essential for all of us that we reflect upon the security response to a threat of from terrorists or persons similar to terrorists, and learn every lesson that we can so as to reduce the potential for repetition, and so as to enhance our capacity for effective responsiveness.
Thank you both very much. I'm afraid our time is up, and a very big thanks to you both for a very lively discussion and excellent presentations.
Thank you, everybody, for this fantastic session. I'm going to give everybody a 1 minute break right now, so you can look away from your computer screen, rest your eyes, and we'll be back in 1 minute with what I promise you will be a fascinating second part of our discussion. Thank you. All right, good morning again. My name is Nicholas Lemos. I am a professor of forensic medical sciences at Queen Mary University of London at the Cameron Forensic Medical Sciences, and I'm delighted today to be joining with our Cambridge colleagues on this presentation. It is my honor to present the first panelist of our second session, Professor Sebastian Lucas. Now, for those of you who may not know much about Sebastian Lucas, I'm going to ask, where have you been during the last 50 years? Sebastian has been an incredible source of knowledge and research and work, both in the UK as well as globally in Africa and Asia. and he will be talking to us this morning about investing in pathology services. And I have to say, before I give him the podium, that I am a forensic scientist, a forensic toxicologist. So I think today I collectively represent the expensive part of the coronial system. So Sebastian, are you ready?
Yes, I'm just going to share my screen.
Thank you.
Thank you very much indeed. And thank you for inviting me to speak. I'm the only pathologist here. And I want to just say two things. First, one, I'm not a forensic pathologist, I'm a medical pathologist. That will come up, that aspect come up later. And secondly, as you will hear, I'm rather concerned that our craft, or particularly the invasive autopsy, may actually disappear. And I think that'll be a very bad thing. So the talk here is about the pathology side of the future of the Coroner Service. I have read many times the first report that the Coroner's Justice Committee produced, and section 4 is on pathology, and it has 4 main points. One, there's a shortage of pathologists. Secondly, the remuneration is not good. Thirdly, about scanning, which Ian Freckelton has introduced very well indeed already. And as he has also talked about centralization, and I'm in a sense building on what he has said. But there's 2 or 3 elephants in the room that were omitted, and these are things that some of us senior pathologists constantly bang on about, and they will come up. And the first one is actually the missing point. I read and contributed to Mike Osborne, president of the College of Pathologists, written evidence to the committee, and also watched him give verbal evidence when the hearings held at the end of last year. And the first thing he said, and the first thing he wrote is, what's the coronial autopsy for? Is it just to differentiate between natural and unnatural deaths? And it boils down to the simple question, coroners, do you want a cause of death that could be registered, or do you want the true cause of death? And this issue goes round and round, has never really been resolved. Its significance is huge because it determines how the service could be run, how much money you need, and all the different expectations that will come out. And obviously, the cause of death is going to be rather more expensive than a cause of death. And I think this omission matters because there are 2 responses the committee must have had, because they would have read and heard that. Either that it was a silly question, the answer is obvious, which then means that the committee didn't really understand what the coronial autopsy business is about. On the other hand, and rather more likely, I suspect they thought it was just too deep to contemplate. It goes into very complicated issues of arrangements, money, employment, accountability, and so on. And also, I think it's the reason why the 3, at least, previous reform documents in my medical lifetime have got nowhere. The second one is something that no one seems to be talking about, and I think is very important. This is information derived from the annual Ministry of Justice coroner statistics. And it's really on trends. Where are we going in terms of the need for autopsy activity? It's interesting, the MOG stats talk about everything in proportion to reported deaths rather than in proportion to total deaths. And so I think it's slightly missing the bigger picture. I have a graph. This is derived from those stats for the last decade. The blue line is the total number of deaths in England and Wales. The orange line at the bottom is the number of autopsies that happen. And it's interesting that actually 20 years ago or more, when I got seriously interested in coronial autopsy work, something like 23% of everyone who died was autopsied. This was, I regard, Britain's greatest and best kept medical secret. Anyway, 10 years ago, it was 19%. And now, depending on quite how you count it, it's 13 or 12%. 12% if it's just invasive, 13 if you include scanning, which we will come to. But it doesn't take terribly much imagination to project that line another decade, but you might see that we autopsy enthusiasts and expert practitioners will simply disappear. So, next one, shortage of pathologists, yes, but it is highly variable. Nationally, everyone says there aren't enough people to do it. The coroners tearing their hair, but actually some places do rather well. And I give great credit to Andrew Harris for steering a very good ship in his jurisdiction in inner South London, where we're very well provided for. We have 2 teaching hospitals with expert pathologists that will cover literally all possible scenarios of death. We have a public mortuary, where other people go. And the crucial thing is actually having regular meetings, discussions of everything. Nothing is barred in terms of our discussions, and we produce agreed memoranda of understanding. And this includes money as well. Compare that with what goes on in Lincolnshire, where simply there's no autopsy activity at all, full stop. Why there's a shortage? Everyone has a different list of reasons. These are just the ones that I like. Because the case numbers are declining, and that's what I said a few minutes ago, basically it gets less visible to the trainees, the next generation. And of course, hospital medicine has decided that autopsies aren't very interesting until they remember that they are, and you do grand rounds in it, and they say, yes, of course, we should do lots more of these, but they don't seem to follow that up with much enthusiasm, unfortunately. It's perceived as being less important than the in vivo surgical diagnostics. There are fewer locations and opportunities for training. And it's a sad fact that actually at St. Thomas's, we are the only big place in London that does any training at all. The other hospitals have given up. There's general disquiet with other coroners' attitudes. This is a rather more psychological aspect about interaction between pathologists and coroners. Obviously, in London, inner South, that is not a problem. And there's the overall NHS attitude, which was that there's nothing to do with the NHS, so it's all going to be time shifted, and you find people doing work rather rapidly, perhaps not very well, out of hours. And another major reason why there's a shortage is money. I'm sure you all know these. The official payment rates have simply not changed for nearly 20 years. Quite extraordinary. Simple cases produce less than £100, complex rather more, and there are lots of additional investigations. Because this has failed really to solve the problem, it's very difficult to get a handle on quite what every of the 89 jurisdictions actually pay, but I ask around as much as I can. And I think most jurisdictions are paying much more now in figures that I've quoted there with investigations. And I think this regional variation is subversive, and I think it's corrosive as well. It's much better to have a universal one where we all know what's going on. Scanning. These are just some snapshots of what actually happens and the pictures you produce. Now, it's a very Marmite issue among pathologists and everyone else. It depends very much on demand and supply. North London, there's a demand for it. South London seems to be rather indifferent. And of course, up in the Northwest, there's a great demand. And one jurisdiction up there has virtually all non-forensic autopsies done by scanning. This means that the diagnoses are actually emerging from radiologists. And is that something we actually want? The local population evidently determine this sort of demand related to ethnicity and religion, but there's less than a dozen such facilities actually working across England and Wales at the moment. Taking the MOJ data, it's interesting that there is no data prior to 2015, and there actually wasn't very much work going on, but you can see on the left-hand side the dramatic increase in activity using what is called less invasive techniques, which is essentially post-mortem CT scanning, such that by the last year, 10% of all the PMs seem to be by scanning. Well, they use scanning. The ones that use scanning only is rather smaller, and quite a lot of jurisdictions will have will scan everyone and then decide what to do. And in many of those situations, it then goes on to an invasive autopsy anyway. But that trend continuing, again, you could project lines to the future, which, if you're interested in actual gross morphology, as many of us pathologists are, is a little bit worrying. There are many issues around this. Where should they be and how many? Costs, which of course is not just the installation, but the annual maintenance, which is not small. Who pays? Who controls the whole process and the outcomes? And who reports the scans? These go round and round in little papers between radiologists and pathologists and perhaps coroners as well. There's every now and then a definitive document, but I just want to address the issue at the bottom. Is it worth doing at all? Now, the answer, of course, is yes, but how effective is the scanning in getting diagnostics? There are two main centres in Britain. Leicester, which has published a paper in The Lancet some years ago, and it actually said on the front page, up to 92% of deaths we can sort out by scanning. Oxford is a little bit more conservative and says it's 70% effective, and that is the figure the college sent to the Justice Committee. I protested at the time, saying it was completely unrealistic, but I was not heard, or at least not attended to. And the reason why it's problematic is case mix. If you select for scanning, diagnostics, deaths in the community among known middle-aged arteriopaths, you obviously get a very high rate of effectiveness. There's no question, but that's not what the work is all about. Periodically, I go through my own casework and see with a list of things that are diagnosable and are not diagnosable through scanning, what would be the outcome if all my cases were scanned? And the short answer is, to get a reasonably accurate diagnosis, only about 30% of the cases I look at, and I'm a fairly general person, would actually PMCT provide the answer, a very different figure from the ones quoted publicly. Autopsy quality issues. This is from the famous NCPOD report, which I have to confess, and I'm rather proud of it. It was my idea, and I wrote, more or less, with a lot of colleagues, and the colleagues included coroners. It wasn't just me and other pathologists. And the quoted figures are fairly obvious, that we thought that a quarter of autopsies were not done, and about 20% we didn't believe the cause of death. Has anything changed? Not really. I see still lots and lots of other people's autopsy reports, and I do spend much time thinking, what do my colleagues think they're doing? A little bit of more granular detail before we come to the solution. This is again from the MOJ stats. You will see that what they call non-standard, that is more special, and the forensic ones, the numbers are going up. And this actually, I don't think the number of forensic autopsies is necessarily increasing. This actually reflects the number of complicated medical cases that are going up. And I think that's an increasing trend, especially with medical examiners, who we haven't mentioned yet so far. There will tend to be a bias then towards looking at the more difficult cases, which previously might not have been examined so much. There's certainly more toxicology, mainly around alcohol, and the histology rate I think is far too low still. My personal rate is about 75%, as is that of my colleagues at St. Thomas's, not 20%. I'm informed already by Mr. Harris that there isn't going to be a national coroner service, which we all rather like, so we're not going to talk about that. But there is another rather simpler solution, or more general solution, that covers the issues, and it's one that Ian Freckelton has already brought up. Basically, it's centralisation. We have too many mortuaries. About 10, 15 years ago, Guy Rutty suggested that England and Wales really just needed about 30 centres, 3 in London and 27 elsewhere. The Hutton report from some years ago and the Justice report echo this, say maybe 12 to 15. I don't know what the number is, but the answer there seems to me so obvious that we should be following this. Some reduced number. There will be a CT scanner for everything. Everything will be scanned first, and then decisions made on whether we need to have an invasive autopsy. And in terms of leadership, I disagree with Hutton, who said that you just need a forensic person leading it. You don't. You want a forensic and a medical autopsy specialist, because they know about medicine and the forensics don't. My final slide with real words on the outcomes, and does it tick the boxes? I think it ticks a lot of them. Total caseload relevance, well, the number of autopsies is never going to go up again. It's only going to go down or possibly stabilize. So we need fewer mortuaries, and we therefore need fewer pathologists. But what we need is better ones overall. And so the autopsy quality issue is addressed. You've got professionals working in a concentratedly as peer colleagues. There will be peer review, and there's nothing like peer review for determining what is good and what is bad. That's how we all learn, I think, reading other people's reports. And any occasional and bad pathologist would simply be frozen out of facilities like that. They wouldn't last 5 minutes, because it'd be quite evident that they're not up to the mark. Training and recruitment will be improved because it will be an attractive place or places to actually go and learn and practice and experience. The NHS needs to buy into this, of course. PM scanning, yes, of course, it's the future. One point I didn't say when I had my PM bit in is that what about all those complicated hospital deaths? They've all been scanned and no answers have come out of that. So of course, there have to be invasive autopsy in these more complex ones as well. Remuneration, I'm not going to talk about. I'm pleased that the report actually notes that there is an issue and is prepared to talk, but it also therefore involves NHS contracts as well, because most of the pathologists who are going to do this are not the forensics, they're going to be NHS and university pathologists. And of course, the major problem is collaboration and money at the bottom. And I'm very pleased this webinar is opening up these issues. And so that is all my points that I want to make. We need to invest, as the title of my talk suggests, we need to invest in facilities and we need to invest in change. And change, of course, is always rather expensive. Thank you.
Thank you, Sebastian. Fascinating presentation and has generated quite a bit of interest. We will address many of these questions during the final panel discussion, but now I would like, with no further delay, to invite Nicola Padfield. Nikki has been a professor in criminal and penal justice at Cambridge University. She's a fellow at Fitzwilliam College in Cambridge and has done a lot of work as a part-time judge in the Crown Court for many years, has written about many cases. And so she's gonna be telling us today her thoughts on how do we handle those preventing future death reports. Nicola, are you ready? Please unmute yourself.
Yes, no, I am ready. Thank you very much indeed. I'm now sharing my screen, which as ever takes a minute or two. I hope that you can now all see that.
It's visible.
Thank you very much. And I think my response to this report is more uncertain than quite a lot of other people's responses. I don't feel that I'm an expert in this field. I feel I'm a newcomer to the field, and the Justice Committee report is really useful, I think, in raising issues, not really coming up with answers. It will be a useful source for many years to come. Isn't it great that the parliamentary committees now put all the written evidence freely available online so we can read everybody else's response too? What does the Justice Committee want? Well, it's a huge hole in the system that there's no follow-up from PFD reports. Of course we need to follow up on them, to be able to explore them, to think about them. What the right body is to oversee these reports, I think, is quite difficult. The MOJ, the Justice Committee, tells us that they should consider setting up an independent office. Independent of who, I want to ask, and how is this going to happen? They hold up the Australian National Coronial Information System as a much better model for us to follow. Of course, I think we all want a fully indexed online repository, don't we? I have been astonished in the year or so that I've been looking at coroners, how difficult it is to find data. So of course, the MOJ or the Coroner's Service or someone should be making this information available. A lot of it boils down to funding, as we've just heard in relation to pathology. We need well-organized and easily searchable information. How easy it is to call for that, how difficult it is, of course, to provide it. One of the questions earlier on asked us about the government's response. Well, I think there's absolutely nothing relevant in the Judicial Review and Courts Bill, or indeed any of the other bills flowing out at the moment. We're seeing increasing number of plans, and I put an exclamation mark there because these plans seem to be empty words to me. Nothing very new seems to be arriving. And it is disappointing for us, of course, that we haven't yet seen the government's response to the committee report. Will we see anything very significant? Who knows? What's brought me into this subject, very briefly, let me tell you selfishly about my project, partly because I'm hoping that there are people in the audience who will email me afterwards and say, you should be looking at these deaths. I'm a criminal lawyer primarily, and I have been intrigued from earlier work to realize that there's very little investigation to many deaths of those on community sentences and those who die on license. There is huge publicity in the cases, rightly, of those who are killed by people on license. And then there's a sort of halfway house level of investigation into the deaths of those who've been recalled to prison. So they're all what I like to think of as criminal justice related deaths. And I think my starting point is to be very concerned about the lack of scrutiny of those who die on license or on community sentences. But then as soon as you start to dig behind these inquests, you do start to worry about what is an effective investigation. And is there any evidence at all that people are learning from the outcome of inquests? Are coroners the right people, and do they have the appropriate powers to facilitate learning? When I spoke to one lawyer much involved in inquest, she suggested to me that I wasn't really asking the right questions, and that it is better to think about how would we design a system to hold public services to account when people die. These are really big questions, and it is extraordinarily difficult to answer them because of the really poor quality of data that's available. So my first category, the deaths on license. Somebody dies in approved premises, well, the PPO will investigate, and traditionally, it's changing now. I'm really pleased the PPO now is seeking to investigate more widely. The coroners I've spoken to say, well, I often wouldn't know whether the person that's jumped off a car park was on license. That to me is an extraordinary answer. I've listed some names of people there, just again, in case there are people watching who want to give me more details or tell me obvious people that I've ignored. I think the big question here is the invisibility. When Lorraine Gelsthorpe and I first did work on these deaths on probation, there was a clear message from the probation service, and this was at least 10 years ago, that these deaths didn't seem to be meriting a lot of investigation, especially if there wasn't going to be any press interest. And that was deeply, deeply shocking, because it's not, of course, just a question of press interest. It's about how we're going to learn. But at the moment, I have to say, it's really difficult to analyze these because there is very little reporting. There's loads and loads of publicity of those who are killed by somebody on license. But again, huge variety in the PFD reports and huge issues, I think, in relation to whether or not the coroner is effective. We've already raised earlier this morning, there's been lots of food for thought earlier this morning about the relationship between the coroner and other investigative bodies. And I think this really is important. Is publicity helpful? Well, are juries helpful? Publicity can be really helpful, but it may also make people often more defensive. There are lots of questions arising here. My third category is the recall suicides. It's impossible still to search the PPO's website, again, to give them full credit. They are working very hard at the moment to make their database more searchable. Difficult to look for recalls at the moment. Of course, they're a really important subset of deaths on custody. Recall is an issue that we should worry about enormously for the number of people for whom recall is in effect a revolving door back to prison. And it's been a focus of my work for many years to look at this back door to the prison, which has not been examined as much as it might be. So preventing future deaths reports. There is no process at all for following up the actions proposed. There doesn't seem to be very much consistency about when a coroner decides to write a PFD report. There doesn't seem to be much consistency in who the coroner writes. There is some legal criteria, there are guidelines, but again, the message of this morning, I think, is that we do need much more guidance and much more consistency. Whether or not a national coronial service would make any difference, I don't know at all. And one of the issues which I think we have to look at in this whole area is what it is that allows organisations to learn. Being a learning organisation is difficult. Effecting change in other organisations may be impossible. And I'm certainly finding the literature on this very useful. Baldwin and Black here that I'm quoting is about regulators, but I think these three factors are useful for us here. The way regulators or indeed coroners think about risks and problems, the operational constraints, money, 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 and then just as big, political, communicative, reputational factors. I think it is really, really important that we put families central to inquests, but actually there are so many other players in the process who also have to be taken very seriously. And there are huge problems, I think, about this, even this hybrid model of inquisitorial and adversarial, how you allow voices to be heard and people to listen. And that's before we get onto this absolutely bizarre world of the number of different organizations involved here. I've been learning so much about MAPA significant case reviews, safeguarding adult reviews. There are many different investigations, and who's the boss? I don't think the coroner is the boss, and I don't think the coroner should be the boss, but we've got a lot of competing forces here to worry about, and many, many contested issues. I pay tribute to Deborah Cole's work, the work of Inquest over many, many years, shouting messages which haven't really been heard. Of course, we all agree that we need an effective mechanism to ensure that lessons are learnt. But it's really difficult, I think, to decide whether it's the function of the coroner to ensure that action is taken. And it certainly can't be the coroner, I think, under the current system, because if they're not meant to rightly suggest what improvements should be made, if they're just highlighting shortcomings, who else should be wielding the whip? No, whips don't help people learn. So we've got these very real problems, which I identify here on this overhead. Problems of delays, the interplay of the different investigations, very complicated stories when you compare different inquests. The intense public scrutiny, Ian has written about sensationalist allegations of ineptitude, etc., make it very difficult for people to learn. Very recent paper by Philippa Tomczak and Sue McAllister of the PPO on the importance of praise. Well, it's difficult. Coroners do sometimes praise, but this relationship between blame and praise, I think there's a lot more thinking to be done. The role of the family we've touched upon, and I think that, of course, we've got to support the bereaved, but we mustn't give them false hope. There can be too much of a suggestion that something's been learnt from the death when actually nothing has yet been learnt. So I then asked some more very fundamental questions, and I'm sorry that I don't have any answers to my fundamental questions. The number of people who've attended this morning and who I'm sure will listen to our webinar later on, I think is really encouraging, because these are questions which there aren't easy answers to, but let's not just satisfy ourselves with cheap and easy answers, which is what we're all nervous the government might actually do. There's very interesting lessons from New Zealand as well as from Australia. I find this book really useful. Two important areas for improvement in New Zealand: consulting with organisations before recommendations are issued. Consulting, what do we mean by consulting? Certainly the inquests that I've been looking at so far don't feel like a real consultation, but maybe it is the adversarial, the defensive nature of the lawyers involved, which make it more difficult for coroners in particular to consult. And it is amazing how difficult it is for the coroner to write to the right people. And do you write to the people at the top? Do you write to people at the bottom? Who answers? There's still enormous difference in practice. I think perhaps having a Coroner Service inspectorate might be more useful than having a national Coroner Service. I'm not sure. We certainly need a much, much, much better searchable database of PFD reports. We need to have the funding, the research opportunities to analyse them and to reflect upon these. There's a million miles to travel in this direction. I have many, many more questions. These questions I'd written before we started this morning, but I do think other people have asked this question about the distinction between Article 2 inquests and others. The discretionary powers of coroners. Coroners have vast powers, and like all discretionary powers, we need to wonder about the surround of these powers. Do we need much greater clarification? The adversarial defensive nature, or do people only learn when their pockets are hit? That would be a sad conclusion that as a rather naive academic, I would be sad to reach. You see, I'm longing to learn more. Do contact me if you want to. I don't have easy answers. My answer this morning is to say, thank goodness that the Justice Committee has brought its voice to look at this. This is a huge issue. How do we learn from the outcome of coroners' inquests? I'll stop sharing now and look forward to your questions. One question which was earlier on raised was by Tom Luce, who asked about national oversight. I don't have an answer to that, and indeed he may himself have an answer. I think the relationship between the coroner and other regulatory inspectorate bodies is crucial. I think it's really useful to have lots of different checks and balances. I think uncomfortable mechanisms of accountability are really useful, but we don't want chaotic mechanisms of accountability. So I'll shut up there and listen to the discussion.
Thank you, Nikki, very much. And thank you for starting our QA session. I'm again happy to invite Sebastian to unmute. There are a lot of questions, and Andrew, feel free to jump in as you seem appropriate. There is a question that was typed in early on, and I think it's really important to address about the coroner's responsibility to alert bereaved families of potential inherited conditions. So how do we handle it now that retention of tissue for genetic analysis is rather vague or even non-existent, from a question from Cordelia Howard. Sebastian?
Yes, Cordelia is an old friend. This is a very important issue. Just one very brief anecdote. Back in 2013, I approached the then first chief coroner to ask him two things. One is, did he think he was accountable for autopsy quality, which includes this sort of business? And secondly, was he accountable for remuneration of pathologists? And he said very emphatically no, at which point I slightly lost interest. Yeah, this is a major problem. And I have to say, we shot ourselves in the foot with the Human Tissue Act and its implementation. We should have waited and done what Scotland did, which was say, and I'm sure in case you don't know, Scotland said all tissues taken at autopsy are to be kept forever as part of the medical record so they can be reviewed and researched as required. We didn't do that. We jumped the gun and said everything's essentially got to be destroyed as a default unless you make a very costly and expensive and time-consuming application to keep it, because that's what it comes down to. And this has actually destroyed a large chunk of the research aspect of the craft of coronial autopsies, which I have loved. The specific issue about inherited, there's really cardiac disease. I think there are better networks coming up, and most places are now generating links with their cardiac institutes who will take this on. I think it just needs a lot more publicity. But I'm slightly disappointed that when I write a report which includes the fact that the spleen is being kept, you can do DNA analysis if you want, the take up by the relatives is actually disappointingly small at the moment.
Fascinating. Andrew?
Can I just add, there is a funded working group which is nationally looking at this. I am one of the people that has contributed to this, which is looking at a protocol and processes and the very complex relationships between the number of organizations and professions will be needed to ensure that appropriate advice investigation is given. So I think it is being addressed at a senior level now.
Thank you very much. Richard Wellings talks about how do we mobilize as experts? How do we work together to present a uniform set of expert opinions and recommendations to politicians for us to guide them to write laws and regulations, as opposed to us being presented with what they've written without consulting us? Nicola or Sebastian?
I'd like Nicola to answer that one.
I'd like you to remind me who asked the question so I could be looking at it while I...
Richard Wellings.
Right, is it in the open question?
It's in the open, and it's about how do we get together a network of experts?
I think a network of experts is a really interesting question. So where I've spent more time, which is in criminal courts, there we've had a real problem with expert evidence, because in contested cases, you get more and more experts coming in, and some of the sudden infant deaths, you've had 11 prosecution experts or whatever. And there's been a move again towards thinking more about Australian methods of hot tubbing and so on, and whether we could agree more with coroners. I think this does go back to the really fundamental point as to what do we mean by the coroner's inquest being inquisitive or investigative. And I think the simple answer to our whole discussion this morning is if we had brilliant, well-funded coroners, the system would be really good. We don't have, not all coroners are brilliant. What is required of a coroner, the skill set of a coroner, is really challenging, and the system is short of money. But as long as it is inquisitive, I think the coroner has got to take the lead. They don't feel at all collaborative, which is what this question is asking about, collaboration. I've been really struck by the few inquests that I've actually attended, how easy it is for them to become defensive or adversarial, And whether there's any way round that problem, I think is the challenge at the heart of the system. And I'd like to throw the question back to Andrew, back to Maya, back to Ian, because it is a question which lies at the real heart of the system.
A uniform voice is needed. Anybody else would like to contribute to this comment, to Nikki's invitation for comments?
My observation is how fragmented the system is. And I mean, there are something like 90 coronial jurisdictions, and they all work on their own, I won't say tunnel vision, but with their own people. And without very much reference, I'm talking about pathology and causes of death outside that. And there doesn't seem to be a sort of general push that we should all be doing better to make sure the causes of death we produce are more reflective of what actually happened. And you will see a question coming from Dick Shepherd there, which he essentially says, are all deaths the same? Are all deaths the same, and who cares about them? And I think that's a very fundamental point. I can't remember whether he addressed it in his book or not. It's a very good book, though. And the answer, of course, is all deaths are not the same. There is, in my view, and I hope I am not criticized by the world in general, by saying there's a sort of slope as to deaths that matter more than others. And just being my personal view, I think deaths in children and deaths in mothers in pregnancy and delivery matter along with the criminal ones, but I'm not getting into criminal stuff. They matter more than people who are at the very end of their lives, who have died of old age, but no one is quite sure which version of old age pathology is relevant. And you have to ask the question there, does it actually matter? And of course, it only matters if something might have been done that would have prolonged useful and active life that wasn't done. I'm not going to say much more about that, but this sort of discussion about which deaths need the most attention. And pathologically, this is my call for more specialization. I'm rather fed up with reviewing autopsy reports by amateurs, and I use the term advisedly, looking into complex scenarios of pathology of which they have no experience whatsoever. And you wonder how the coroners let that happen.
To go back to the point that you make with Richard Shepherd, this question about the ethic of care, I think is really important. Who does care is very basic, and it's quite difficult to care, I think, in the context of complex inquest with many parties all trying to make it clear that it's not their fault that this person died. So thank you for that question from Richard Shepherd. I'm sorry, I talked over someone. Was it Andrew I talked over?
No, I was going to say that at the suggestion of Dick Shepherd many years ago, I took a job in California, and the first thing that the chief medical examiner told me when I moved to San Francisco, he took me to the side and he said, "Remember, Nicholas, dead people don't vote. Nobody cares about what we do." And so, Dick, I think that's an answer, a partial answer about whether or not politicians care or the family cares. I know that I agree with Sebastian that different deaths matter differently. Now, many deaths that are on social media seem to matter much more than those that are not on social media and they're recorded. I have to also ask a question that came back from a comment that Sebastian made about virtual autopsies. At Barts End in London, our own Curtis O'Fire, who's a radiologist, is in charge of our CAT scan and postmortem scanning. And so now, oh my goodness, I saw your gesture. I'll let you comment. Go ahead.
I think that's terrible because they don't understand clinical pathology, full stop.
Full stop. I see. Anybody else wants to add anything? I mean, right now you're asking, perhaps we're saying that virtual autopsies should be the way of the future. So does that mean that our pathologists need to learn radiology and practice it and be able to not consult with the radiologist, or have radiologists just be another testing element of the pathologist agenda to do?
A few of the pathologists who've taken PMCT to heart, and I particularly mean people like Guy Rutty, people like Ian Roberts in Oxford are very good. They're as good as the radiologists, probably, although they always defer to the radiologists who have also had training. And basically it's consultation between two equal parties going on there as to what we know, what we don't know, what the uncertainties are. What gets my goat is what you originally said, Nicholas, is about radiologists who really have had no experience of pathology and what happens in death, just simply looking at black and white images and saying, oh, it's obviously a pneumonia, isn't it? And there's no quality control there.
And so are there any external quality assessment exercises that we should be putting in place that you feel are necessary?
Well, this has come up as a question I've seen already, and I've actually answered it in typing. Someone said, what about EQA schemes in autopsy pathology? First thing to say, the forensics do it already, so let's take that aside. But the forensic autopsy proportion of the total casework is tiny, and it does slightly become the tail wagging the dog sometimes, but it can be a very good tail. There haven't really been any, and no one quite knows how to do it. Someone said, well, let's do some histopathology of standard cardiac deaths and see if people get those right. And that worked for a bit, and it was very interesting to those who are interested in cardiac pathology, but it didn't generalize. My solution is really quite simple. So people should be fed anonymized, possibly doctored somewhat, autopsy reports, which contain errors and obvious things that are wrong. And you've got to pass a test of spotting those errors. And if you do that, you learn. The biggest education for me in improving my attitude to correct diagnosis was the NCPOD process, where we looked at about 2,000 autopsy reports, a whole group of us, and we all realized within 10 minutes what a useful exercise this was in seeing what other people did, the good things that some people did, and the bad things that people did. And that's how we learned. And I really think everyone should be doing this. But of course, you're not encouraged to share autopsy reports. It goes against some of the regulations and even the law, I am told by Andrew.
I have to say that recently the National Association of Medical Examiners in the USA has published a paper where one of our British colleagues here, E.T.L. Drawer and Judy Melinek from Cameron Forensic Medical Sciences, they did a blind study to show whether or not pathologists would differently catalog deaths based on race by just taking one word or two words out. And the results were shocking about the race bias that actually was found by the pathologists. That wasn't very well received by that group themselves. There is also another question by Stuart Hollington, and I know I'm conscious of time, but he talks about this private equity that happens between crematoria and also lease back services to local authorities. So Stuart asks, do we see any reason why such a model of almost like a PPP couldn't be applied to the Coronial court and mortuaries to provide large modern facilities, such as the Gloucester model? Any thoughts?
I think it's a terrifying model of privatization gone crazy, in the sense that do we want to privatize more of our courts? The long-term costs would not shrink. And I go back to some of what Maya said right at the beginning about digital justice generally. We need well-funded courts, and I'm not at all sure that we want to think about coroners in the world of PPP, but I'm very skeptical about the advantages of privatization in this area. Others may disagree.
Any other comments on this? Andrew, how do you feel about that?
Well, I don't think it's for me to answer. I think the issue is what is the best way of achieving a good quality service and good outcomes. I think it's for others, for politicians, for organizational people who design organizations, design the best way in which public and private work together. So, but I think it's wrong for me to have a view other than wanting to achieve a high quality, good outcome service.
At least not on record. Remember, this meeting is recorded. Now, the other thing I want to say is that there are comments about the problems that exist with the drawer paper that I just mentioned. And it is true but it is also up to us to come up with better research to try to answer this question. So criticizing the others and not doing anything about it, that could be a problem as well. Now, an anonymous attendee has actually asked, do you feel that medical examiners now function as a repurposed medical lens, given they don't address another shipment like when they were supposed to? What is the opinion of the panel on the medical knowledge of coroners?
In my world, the inquest very rarely turns on medical evidence, because the question in the criminal justice related deaths are about why on earth did this death happen? Why didn't anyone spot it coming? Why wasn't wider society institutions, public sector, private sector institutions, why weren't people more aware? So my sample, if you like, is very biased, and I need coroners who are good lawyers and good human beings more than good doctors. If you look at the medical failures, of course, there's another problem there, which is doctors investigating doctors is always going to be problematic. But I see Andrew has his hand up.
Well, just briefly to say, the focus of medical examiner scheme, which I'm a huge enthusiast, and we have very good, strong working relationships in my jurisdiction, alongside the pathologists. We all meet together and discuss cases and the way in which we should work. The focus is on advising the coroner about about the cause of death, what it means, when it needs to be reconsidered, whether an investigation needs to be opened. So it's not really at the inquest level, the medical examiners are valuable, but despite being duly qualified, I have found medical examiners a huge benefit to the system in quality and efficiency since they've been operating.
In one final group of questions, so does the panel agree that the way of the future is the post-mortem CT scan models, and that could help us in a hybrid world where we save a lot more resources by employing PMCT more regularly in centralized ways?
Let me answer that, and I agree. It is the future, and you're not going to turn that back, even though some of us don't actually dabble in it at all, like me. But it's all part of the package of having fewer, better, concentrated expert centres. It's simply one aspect of it. And I have several coroners in London have individually and collectively asked me to sort of write papers on what do we do about CT scanning in London, and I make the obvious comments about, well, you know, decide who's going to pay for it and where do you want them, and we never get very much further than that because it is a very complicated issue, and it really comes down to the funding of the Coronial system and the funding of the mortuary systems and the interaction with the NHS and the local authorities and so on, which is a sort of minefield which is going to have to be trod on. I was going to say grasped, that's mixing metaphors too much, has to be trod on in order to make any progress at all. And I just want to see the willpower to actually do this. And I get rather depressed. I'm very near the end of my professional career, as you might imagine. And I just have this awful feeling that nothing is going to get better whilst I'm still alive.
Thank you, Sebastian. Thank you, Nikki. I am delighted with how this session went. Andrew Harris, will you please offer us your closing thoughts and remarks? Thank you all.
Thank you very much. It's been an extraordinarily stimulating 2 hours. We have, and are very lucky to have very experienced and thoughtful contributors, both panelists and questions. It seems to me that questions have been raised about the structures and processes of our organizations, but also importantly by a number of panelists about our relationships. So whatever the government plans are, we need to work on having good and effective relationships between our professions and disciplines. Ian's contribution has been hugely stimulating in considering the importance of learning from other jurisdictions. And again, when we see what the government's reports are, there will be important lessons that we can take forward. It's also clear, particularly from Nikki and from Sebastian, that there is a need which may not be realized, and we may all have to continue to work on, about the clarity of purpose. And questions such as how much we can achieve putting the bereaved at the heart of the process, and how consistent that is with the statutory 4 questions and the equal balance to interested persons. And of course, the issue that Sebastian has raised as long as I've known him, over 10 years, do we want A or the cause of death, remaining perpetually unanswered. The issues for all of us as professionals working in the service about dealing with inconsistency raises questions about standards, training, support, and capacity. I think the Coroners and Justice and Courts Bill, although people have indicated some disappointment, may create, from its changes, capacity for coroners to divert some of their efforts into reducing delays or improving other aspects of the service. And perhaps it also creates an opportunity for amendments to be put forward, which could be useful to address some of the long-term needs of the service. I don't think I can say any more given the richness of this discussion. It's hugely encouraging that over 100 participants have taken part, that there is such an interest in what has been in a way a niche area that politicians haven't always taken a great interest in. And I think we should congratulate the government for setting up the Justice Select Committee and moving these thoughts and plans forward at a time when there were a lot of other difficult challenges for the government. And Nick and I are certainly thinking about the possibility of having another webinar when the results are through. Please do stay in touch, and we will be very interested to work together on taking these matters forward. Finally, a very big thanks both to Nikki and Dan for setting this up, and to our 4 panelists who've given their time very generously and very thoughtfully shared their experiences to our benefit. Thank you.